appraise marital property. Ms. Locke, it's your motion. What is the status of these motions?
Yes, Your Honor, we have not been able to reach a resolution, so we would like to be heard on both motions today.
All right. How can there be an objection to appraising marital property?
Okay. I think that we have resolved that. Ms. Locke, I think we will agree to use marital assets, and then we'll split them equally between the parties to pay for it. And that was the only issue. And the 10 acres to the son. We want to make sure the 10 acres to the son, we understand the parties have agreed and they are not be included in the appraisal. So if we have an agreement on those terms, this is not an issue.
Yes, there's an agreement.
Okay. Okay, so who's going to submit the order? Because there's additional conditions, so I want an order on it.
I will do that.
Okay. Can 10 acres do you any good in Butler County? You got to have 40 acres to build anything unless you get an exemption from the county commission, unless it's not in Butler County.
And registered with the deeds.
Okay. I understand it's already been surveyed and registered with the deeds, so we have already taken action on the 10 acres.
Okay. Okay. Your client is the plaintiff, Ms. Locke.
Yes, Your Honor, the petition. Correct.
She filed the order.
The hearing opens with a dispute over temporary financial responsibility. Counsel argues that the husband remains in the marital home, earns significantly more, and has flexibility to reduce expenses like internet and cable. The mortgage alone stands at $2,500 each month, a major obligation someone must pay. Attention shifts to unresolved motions, including modification of the temporary order and appraisal of marital property. The court quickly questions why any party would oppose an appraisal. An agreement is confirmed. Marital assets will fund it, costs split evenly, and certain acreage excluded.
And she filed the temporary, but she wants to modify them. All right, you may proceed.
Your Honor, when this case was first filed, we believed that the parties were in agreement about most of how the case would transpire. And we find ourselves months down the road without reaching much of any resolutions. When my client first filed, she agreed to vacate the marital residence and live temporarily with family friends in Topeka. Her situation has changed due to the length that the case has been pending, and she had to seek alternative housing options closer and in Wichita. That has necessitated her needing spousal maintenance. Prior to the separation, the parties agreed to split their excess income monthly equally, which resulted in them each having about $800 in discretionary income after things were paid at the household. When she filed for separation, that $800 continued to come to her.
With preliminary issues resolved, the court turns to spousal maintenance. Counsel explains that when the case was filed, cooperation was expected. Months later, little progress has been made. The wife vacated the marital residence by agreement, initially staying with friends, but delays forced her into rental housing closer to Wichita. Before separation, excess income was split evenly, leaving each party about $800 monthly. That arrangement continued briefly. However, counsel now emphasizes a growing income disparity, arguing the wife no longer has sufficient funds to meet basic needs while the case remains pending.
However, There's a huge disparity in monthly income, and now that we haven't reached resolutions, she needs some additional monthly income in order to be able to survive. Ms. Sawyer gets about $1,000 a month from Social Security. Mr. Sawyer gets about $6,800 a month in monthly income between his pensions and then his Social Security payments. He has been responsible for several of the bills. The largest bill that he is responsible for in the temporary order, other than the mortgage on the marital residence, is my client's car payment. And I will give the court a little bit of history on that. The parties sold off some pretty significant acreage not long ago after she purchased her car. At closing, Mr. Sawyer elected to pay off his truck and some other equipment that's at the marital home and opted to keep her car loan because it had a low interest rate. At that point, he agreed to continue to pay her monthly car payment.
Income figures become central. The wife receives roughly $1,000 monthly from Social Security. The husband receives approximately $6,800 from pensions and Social Security combined. Under the temporary order, he pays the mortgage and her car payment. The car payment history is detailed. After selling acreage, the husband paid off his own truck but chose not to retire the wife's car loan, citing its low interest rate. He continued paying it monthly. Combined with income division, this leaves the wife with about $1,800 monthly, while the husband retains substantially more discretionary income.
And has continued to pay her monthly car payment despite there being funds at closing to pay off her car in full. So at this point, he pays her monthly car payment, and then they divide that extra $1,600 a month, giving her a total monthly income of about $1,800 to his $6,000. So what we're asking the court to do today is to make that a little bit more equitable. Essentially, we're asking the court to give her approximately one half of his one of his pensions monthly, which we believe will be close to what the final outcome is in this case. So we're asking the court to award her formally $1,800 a month in spousal maintenance, which is in our motion. We believe this is supported by the factors. Both parties are retired. He lives in the marital residence. He has more discretionary income. He has more regular monthly income, and he has the ability to cut some of his bills back, including internet, cable, things of that nature. My client needs to be able to survive in.
The request before the court is framed as equity, not excess. Counsel asks for formal spousal maintenance of $1,800 monthly, roughly half of one pension, anticipating a likely final outcome. Both parties are retired. The husband remains in the marital home and maintains his lifestyle. The wife must cover rent and daily living expenses without access to marital funds. Counsel argues the husband can reduce discretionary spending, while the wife cannot. The court notes the 43-year length of the marriage, underscoring the seriousness of the request and the long financial partnership involved.
A new rental in Wichita until this case is resolved. She has no access to any additional income. All of those items are held by the respondent in this case. So we're asking the court to award her formally $1,800 a month in spousal maintenance.
All right, 1982. That makes this about a 43-year marriage.
Yes, Your Honor.
As of yesterday. Mr. Morgan, your client hasn't filed a domestic relations affidavit that I can see.
Yes, we have, Your Honor. I will show you. Can I share screen?
Sure. What, can you give me the date so I can try to find it?
Oh, I think it was either last week or the week before that.
Okay, well, it's not in the court file. Okay, here we go. I got the response. You may
Okay.
proceed.
In the first paragraph, I point out that here's what he's paying for the petitioner. Car insurance, $50.
Defense counsel responds by highlighting existing payments. The husband already covers car insurance, the car payment, the cell phone, and $800 in monthly support, totaling approximately $1,370. Counsel argues this arrangement equalizes net income between the parties. A domestic relations affidavit is referenced to support these figures. Counsel contends the husband cannot afford more without shifting expenses back to the wife. Credit card usage is explained, noting expenses are tracked without double counting. The argument emphasizes balance, warning that increasing support would push the husband into a financial deficit under current obligations.
Car payment, $435, cell phone, $85, okay? And he has paid her $800 a month. And this is a total of $1,370 per month. All right? Now, we're asking the court to just keep it the same because we believe that this makes everything, the net incomes of the parties, equal. And we believe that that's the fair way to do it. Okay, we go on to our next paragraph, number 2. We did send an email to counsel. We were a little late on the DRA, but 2 months ago, we outlined this and we said, here's his income, $680. He pays bills. This leaves $260. We pay her $800. He keeps $800, and their net incomes are the same. And that's what we've been doing, and that's what we believe the court should continue doing. All right, paragraph 3, the DRA we submitted for Mr. Sawyer supports those statements. He does not have the financial ability to pay any more. And if the court does increase this,
court probes expenses closely. Questions arise about electric bills, credit cards, hobbies, and entertainment costs. Defense counsel explains that $500 monthly covers all activities outside the home, including modest recreation. Attention turns to Medicare, with debate over whether health insurance expenses are already deducted from Social Security benefits. Exhibits are discussed, some received only the day before. The judge signals concern over limited time and indicates the matter may be taken under advisement. Both sides acknowledge unresolved questions, particularly regarding documentation, monthly spending, and how accurately.
spousal maintenance above what this is now, we request the court to shift her expenses back to her. And that would be the cell phone, the car insurance, and the car payment. Now, that just involves a lot of work and shifting. We don't think it's necessary. That's why we believe we should continue as is.
Okay.
All right, now let's go to his DRA.
Okay. Well, my impression is that she will, if she got the 1,800, she would do the 85 cell phone and car insurance, but the car payment is in dispute because he just took that on as his debt when at least, I mean, if his truck was paid off, he